A lot of these things. First and foremost, you see what's up there? Not making findings and conclusions. That's why I had a little bit of a heart attack when you made that comment. And I was going, they're not making findings and conclusions, and you are, so you're good.
I just haven't been through a
no, and that was not a personal slight against you at all. I just, but it, you know, as a defense lawyer for cities, it was like, oh man, you know. And the reason I'm saying this, I've had to defend these before. Whereas, in fact, I'll give you a quick example of this. I got a call about 5 years ago from a city up north, and it was from the planning director, and the planning director said, hey Mike, you know, we just approved a variance after a hearing last night on this project, and I had a big argument with the mayor of this particular city about this, and you know, they didn't adopt findings, they didn't even make any findings on this, they just said, oh, variance denied, and let it go at that. And I told him I thought we needed to do findings to support that, and he said, no, and then he tells me they've never in the history of the city done findings to support or reject a variance in the whole history of the city. And apparently that's what the mayor was saying. I went back through the records and we've never ever done findings, we don't need to do them. And his planning director was calling me saying, you know, am I wrong or something? And I said, no, you're right. You're right. And I found 5 court cases, one that was only a year old, invalidating variance decisions because they didn't have findings associated with them. And I did a little confidential memo and sent it up, and I said, you folks need to revamp your process immediately and make every variance decision. And then it turned out that some of the CUP, conditional use permit decisions, they weren't doing findings with those either. And I'm going, oh man, I don't want to be hearing this. They were lucky they hadn't gotten sued, but my point is a lot of cities and decision makers don't realize you need to support quasi-judicial decisions with findings and conclusions. Again, you can do it through adoption by reference to staff findings or planning commission findings, whatever. Ignoring or not applying the law, I've talked over and over and over about that, but you know, if you're given a set of criteria and standards to apply, you need to use those. Applying the wrong law, I gave you an example in the case Cox versus City of Linwood, about a 25-year-old case where the city just, you know, didn't like this guy's application for boundary line adjustment and imposed upon him compliance with short plat standards, not the boundary standards, and he couldn't meet those, and it got denied, and he sued and he won, and he got a whole bunch of attorney's fees, and he found personal liability against, and I believe it was the planning director that had actually made the decision. So all those kind of parade of horribles I was just talking about, invalidation, money damages, personal liability, all happened because they applied the wrong law to the application. You don't have evidence to support the decision. That, you know, again, if you got findings, hopefully you can target those findings to specific evidence. Ignoring evidence in the record, and again, I've had numerous times where decision makers say, oh, well, I didn't have time to read the applicant's engineering report. It was 200 pages, and I didn't think I needed it. I know what the traffic's like on 215th Street. I don't need a traffic report. That's arbitrary and capricious. You're obligated to review the evidence that's submitted. You can give different weight to it. You say, well, this guy's engineer had a much better report, it's much more detailed, he's got better qualifications. This guy's engineer's report was only a page, it didn't have his credentials, and didn't make sense to me. That's fine, but you gotta review the evidence in the record. Imposing standards or criteria not authorized by state law. So I had a case where a preliminary plat decision got challenged in court because the city required the applicant to put in all sorts of plantings and bufferings and a sidewalk around the perimeter of a big box development. And there were no standards or code requirements allowing that or even recommending that. The staff and the elected officials just thought, hey, it was a good thing and we needed it and it would help shield this big box development from prying eyes in the public, and we lost that. And it got reversed and remanded, and that condition got stricken because it wasn't authorized, okay? Waiving standards or requirements, same kind of thing. We don't cut deals with people. Ignoring city attorney advice, and I mentioned this Mission Springs case, it was a big ugly case, Spokane, where they the city attorney stood up, not what I would have done, but in an open public meeting and said, if you try to change these road standards at this point, you're violating this, this, and this, and it's arbitrary and capricious, and you're going to get sued for RCW 6440 damages in 1983. And by God, it's exactly what happened to them, and they lost. And the state Supreme Court, I've never seen this before, actually quoted the city attorney's advice in the decision. It's in the decision. And it was spot on. I'm going, yeah, he hit the nail on the head. And in fact, there's evidence on the record in that case, and I shouldn't harp on it, but it's a great example of what not to do. A couple of the mayor, I believe it was the mayor, got on the record and said, well, we've heard from the city attorney, we don't necessarily need to follow that. Let's let them sue us and see what happens in court. Literally, that was the line in there. And guess what? They sued, they won, they got a whole bunch of money, and several of the council members got sued individually in that case. So,
Mike, real quick, because we've had a couple of.
Sure.
Can you go back to the back one?
Oh, sorry.
On that weighting standards and requirements, that's different than when in a conditional use permit or some process where the council has in its processes the authority to make recommendations on a minor modification in a mixed-use final plan or an alteration. I'm trying to say it in general fashion rather than specific.
For example, if a section of a development agreement says the standard for this aspect of the building is X, however, this standard may be waived upon a showing of A, B, C, D, and E.
Completely different. Good point, and I should qualify that. And all of these are, well, not all, but some of these where I'm saying don't do this, do that, follow the code. The assumption is that your code doesn't authorize that. If your code has any kind of provision or the development agreement or an approved master use or mixed use permit provides a basis to waive those on the basis of staff's discretion or somebody's discretion or for whatever need, absolutely. Then you can do it. What I'm talking about here, so you're right. You're right.
I wanted to clarify that.
No,
some of the decisions of late, a couple of them were construed and continue to be construed as we violated our own requirements and regulations.
Now, if the requirements, the code, the development agreement, whatever's governing the project allows for waiver, discretion, modification, absolutely. Well within the ambit of authority to do it, no problem. What I was talking about here, I've had, I don't know how many cases where developer comes in and says, well, I got a requirement here to do frontage improvements on this this site plan, and I don't think it's necessary because there's no frontage improvements on the adjoining lot, and the planning director or decision maker says, well, don't worry, if we don't need that, we can waive it in this case. That's different because what I'm talking about, there's a clear standard or requirement, and the city's just cutting a deal basically. With a developer, you can't do that. Yes, sir.
You don't need to go back, but on the previous slide it says potential personal liability. Can you explain that and maybe give an example of where someone was held personal liability, presumably a council member, for a decision that was made?
Okay, give you a good one. The Mission Springs case, that one right there. Yeah, and I can't recall. It's been a while since I read that. I think it was a 1992 decision. That case, I believe several of the council members, in addition to the mayor, were named as defendants personally in the lawsuit. So the lawsuit was Mission Springs Development Corporation versus City of Spokane and Mayor XYZ, council members, blah, 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 as defendants. So that's what I mean when they get named as a defendant. And what that means is that in addition to obtaining damages from the city as an entity, as a corporate entity, they can, in addition to that, get damages from the individuals personally, and also, so separate damages because they've acted arbitrarily and capriciously on an independent basis, and in some cases they can get punitive damages personally for really egregious conduct. It's tough to prove, but it happens. And they can also, the individuals be tagged for personal attorney's fees to the plaintiff, the person that's suing. If they win these types of cases, and this one was a classic example, this Mission Springs case, and I got the citation if anybody wants to, have an insomnia and they want to pull that up at night and read this case. It's one of the land use lawyers, Bob knows it well, turns our stomach. It's the last thing we want to see. The mayor, I believe a couple of the council members, personally named, held personally liable. They tried to get out of the lawsuit claiming they had immunity, and the court just struck it down and said, no, not in this case, because what you did was flagrant, and it's not qualified immunity because you didn't act in good faith. and that's where they came back and quoted from, they said, your own city attorney stood up there and told you, don't do this, you'll get sued. And they basically said, let's take a chance, let's roll the dice, see what happened. That quote came back to haunt them. And so they were held liable, and ultimately, I don't know who paid how much, but it was a pretty big judgment. I think it was, well over $1 million. And the decision got invalidated, and there's a horrible court decision out there. And I know that I've talked to people that used to work in the city of Spokane, and they go, I wish that thing would go away, I don't ever want to see that case again, but it's there, so.
Well, I think the new one's brewing in the town, I won't name it, it starts with initials of BD, south of Rainbow Valley. Where the attorney.
Bob, you know anything? No, I'm just.
Literally telling the council members, if you do this, you could be personally sued, and yet they're still conducting themselves in the fashion. So that's why you get paid the big bucks.
Absolutely right, and listen to the mayor on that, and I will tell you, and I'm not speaking out of, the city of SeaTac got tagged last year, $12 million land use decision, largest one in the state's history, huge amount of attorney's fees, and I believe the mayor in that case was also held personally liable. There were a number of defendants in it, but the same thing, they were kind of ignoring city attorney advice, made some bad land use decisions, were trying to, slow down and delay a development project to try to get the developer, the property owner, to sell the property to the city for a parking garage. They got a lot of publicity, it's a bad decision.
And the city created a straw LLC,
Oh, yeah.
corporate entity, to buy the property so that the property owner would not know that they were in a transaction with the city.
It's got all sorts of.
Those facts bothered the trial judge a lot.
Yeah,
Based on his comments that he made as part of his ruling.
And Bob's absolutely right, and that's another example of, there were some really harsh comments by the judge. I got the audio of that a friend sent me, and it was just scathing, like, this isn't the way government operates, and they started off by saying it's a quasi-judicial matter. So everything we're talking about here, I'm not making this stuff up, this isn't from a textbook, this is real stuff and causes real problems. But if you follow these rules, you're going to avoid, you're going to avoid 99% of any potential problems. So let me go through this real fast because sorry.
On quasi-judicial matters, the planning commission looks at everything that ultimately we would review to make a decision. And the planning commission, I don't know what choice they have. I think they always have to make a recommendation. Do they have some flexibility, and do we have some flexibility on ultimately making a decision that might be contrary to the recommendation of the planning commission?
Well, let me take that second part first, because that's a great point. So the answer to your question on the second one, do you, the city council, have flexibility in accepting, rejecting, or modifying a recommendation from the planning commission? Did I state that right? Okay. The answer is yes, absolutely. And in fact, you should, as the final decision maker, the city council, scrutinize a recommendation and make sure that it does all these things we're talking about. Is consistent with and follows the requirements of the code, that it follows the right process, that it doesn't have any of these arbitrary and capricious issues in it. And if you, the city council, believe, and to answer your other question, you'd be reviewing, I assume, the exact same record that went before. So the planning commission is going to take in testimony, review a record, and then forward a recommendation to the city council for decision. Recommendation will be approve or approve with conditions or deny or whatever. You should scrutinize that decision, a recommendation. You should independently review all the evidence, and you should look at the proposed findings and say, do these make sense? Are they consistent with the code requirements? And I'll give you an example. If you got a recommendation from Planning Commission on let's say a big box development, we keep talking about those, and one of the findings, well, I'm not trying to focus, I don't even know if you guys have big box issues out here, but everybody else seems to. I'm so tired of Walmart issues that I can't stand it. I've seen a million of them. that, let's say you get a recommendation that says, recommendation is to deny, site plan application. Here are 5 reasons, 5 findings, in part. 200 citizens showed up and objected to the application, saying that it didn't fit the pattern and policies of the city and was out of character with the neighborhood, that it was going to cause all sorts of problems, for citizens. It's going to create noise, but there's no noise report and things. Those are all red flags. That's where I would be going through scrutinizing that. Wait a minute, where's the evidence to support this? Well, first of all, Mike told us we can't make decisions on, not my backyard complaints. We can't do visioning, and that's what they've done here. This isn't a popular vote issue. I'll give you an example. I defended, and we got this reversed, we won the case by a hair's breadth, but it was a bad decision. It was, and I was lucky. I got the plaintiff they didn't file the appeal in time. I got the case dismissed, but on what I guess I will happily say was a technicality. But it was a site plan application for a controversial apartment complex, and the city council was getting just deluged with citizen complaints about it, and letters and emails. Quasi-judicial, they shouldn't have been considering any of that. I got brought in after the decision had been made, damage was done. One of the decisions, they did findings and conclusions to deny this site plan for the apartment, and one of them was over 300 people packed the high school auditorium and spoke in opposition to this, and the only person that spoke in favor of it was the developer. It was 300 to 1. They literally put that in a decision on the site plan, 300 to 1. Irrelevant. It's not a voting contest. It's not who has the most people for or against. They completely ignored the criteria for site plan approval. It wasn't even mentioned in the decision. I mean, it was just wrong on every level. So that's a classic example of what not to do. I mean, there was a whole bunch of other problems with that too. I mean, there was appearance of fairness issues. I mean, it was not my favorite case to defend, but the guy that appealed it was an attorney, didn't know what he was doing, and he missed back then it was a writ deadline, and he was off by 4 days or something. Dismissed on that. Thank God, because we would have had to find a way to settle that, because we were in big trouble. There was no way to win that case on the merits. Yes, sir.
Or Mike, just sorry.
No, I'm sorry.
Quick check-in. We're still in past 9. Are you all? There's many slides left. I think there might have
47 slides left.
Oh, you have 72.
Well, the last part of them I wasn't even going to cover. There was about 10 of them I wasn't, but I'm glad you reminded me.
I'm sure there's some Q&A wanted, but I know some folks are going to need to get going.
Yeah. Let me.
Are there any the highlights you want to hit on that you have?
Yes, and let me do this. If I can, I think this gentleman's question, and then I will zip through, because I now covered a lot of the stuff that's in these forthcoming slides. Kind of zip through real quickly, touch on the appearance of fairness, and then take questions, because I appreciate that. Sorry, you kind of got a taste for how this goes. Bob, do you want me to cover specific stuff?
Can I just ask a real quick continuation of that last one, and if it's longer than a 2-sentence answer, we'll pass. But what happens if, in this scenario, the planning commission did not make a recommendation for whatever reason? They've held their public hearing, but now it's sitting with council. Can we, as council, pick that up without having a decision?
I would send it back. If your code requires, as part of the process, keep these words short, that the planning commission make a recommendation, they didn't do that, my response would be the council sends it back with instructions to the planning commission to make a recommendation. I wouldn't act on it. Disagree?
No, that's right, I agree. Follow-up though, does the planning commission have the discretion to say, we don't want to make a recommendation?
I think if they're...
If the land use decision type says, planning commission recommendation, council decision.
I think they're obligated to make some kind of recommendation. I don't know how you get around that. And Bob raises a good point. Real quickly on that, I guess I'd go to the verbiage of your code. If it says shall or should, makes a difference, right? If it says shall, I think they're mandatory obligated. If they say they refuse to, then have the council maybe vote to have the hearing examiner make a recommendation. I think somebody needs to make a recommendation to the council. And if the code basically says planning commission should make a recommendation, that's, more flexible, not necessarily mandatory. But I've never heard of that before. That's a new one. And I'm sorry, this gentleman, yeah.
Being planning commission, we have most of the time public hearings, but what I'm reading here is, why bother public in those hearings? Because we're not gonna actually consider those in our decisions, we're gonna follow the guidelines, right?
You are, but you do get to hear comments and testimony from citizens at that hearing, but just as to the criteria in the code. So the
Which
citizens.
no one knows.
What do you mean, which no one knows?
The public doesn't know. You guys no idea what we're doing. Just look the code off.
Okay,
They're here to comment about it's too noisy, it's an eyesore, it's gonna cause too much traffic, it's gonna reduce property values by 20%. You don't even have to have data for that.
Okay.
Yeah, just to follow up on that, I'm sure they learned it in that meeting, right, what the code is. So when they came first time, they didn't know, but they learned it what it is.
You're talking about people who go to the top planning commission meeting and then come to
No,
this.
on your example, but just follow up on the question which I'm asking is, of course, they don't know, but when they come to the meeting, they learn about the process and, what guidelines we follow. But my question was, we, send these invitations to public to come to these public hearings, the planning commission is gonna consider topic X, right? But as a planning commissioner, we are not supposed to take their feedback or their comments into our decision making. Then why do we invite them to our meeting?
No, you don't, I guess you misunderstood. You do take in the evidence they provide through their testimony, but only as to the criteria in the code. In other words, what I'm telling you over and over here is, they can't come in and just say, I object to the Walmart because I don't like big box developments. Or I object to Walmart because it's gonna change the character of the city. Those are improper reasons to make a decision on a Walmart. But if they come in and say, well, this is going to have a significant impact on traffic, here's why, I live on this street, it's got too much traffic already, and code criteria number 6 says, as part of making a decision on this, that you need to take into account impacts to traffic. That's perfectly acceptable, because it's testimony, it's evidence on a point that is a criterion for approval or disapproval. Does that make sense? Okay, I may have confused. I'm not saying don't ever listen, but the 2 points again to make. One, these comments need to be made at the public hearing, the properly noticed public hearing on that application, number one. Number two, the comments need to relate to the code criteria that govern, that is the law that govern the application. So if it's a plat application, for example, there's I don't know what your code says, but state law says there's a whole bunch of things you take into account to determine whether a plat should be approved. Is there adequate provision for safe walking conditions? Adequate provision for potable water? People can come in and testify. There's not sufficient water in the city of Spokane to service this 400 lot subdivision. That's evidence that can be taken into account and considered. But if they come in and say, we don't need this plat, I don't like the developer, or it's gonna ruin my view in my neighborhood, view is not a criteria for plats, that should not be considered. People will say those things, but they shouldn't be considered as part of the decision making. Okay?
Like, to that point, there's maybe some of the gray areas when a citizen says something to the effect that, because they're talking to the criteria of environmental impacts on traffic, sewer, water, home values, where it might be, don't want Walmart because it's gonna cause my property value to drop by 20%.
Okay?
And or it's gonna affect the migratory pattern of birds that go to the wetland just beyond. And I think someone made the comment, or Sean did, that should that go on the record or not? If it's not backed up with any kind of substance or evidence, someone conjectures. That's where it seems like there's some gray areas where it's kind of hard to draw that line and say what pertains, what doesn't.
Yes.
Your Honor, I object, that's hearsay.
Yeah.
How would go in law and order?
I don't know, I don't get paid what they get paid in Law and Order, that's for sure. So, let me respond. So you're right, there are gray areas. This gets back to having a strong chair, I think, that controls the hearing and keeps the people testifying focused on the criteria. That's number one. Keep them focused. So if they get off track and start talking about, for example, property values, okay? I'll just point, if your code doesn't establish reduction in neighboring property values as a criteria to consider for application X, you don't consider it. It's irrelevant.
And you can't, right?
Right.
You don't.
And if you
can't.
do, if you base a decision like we heard from 20 people saying their property values are going to drop by 15% if this goes in, that's arbitrary and capricious. That's a quintessential example of it. Unless your code says, here are the 10 criteria for a site plan approval, and one of them is showing a substantial reduction in property values for neighboring property. Then you can consider it. But otherwise, no, you can't. So again, I keep going back, you've gotta focus on the code. Let me say one other thing though, I'll answer the questions, because I think this will get to, maybe it was, somebody made the comment about, well, these people come in and they don't know. No offense, they need to know. And they need to know because the city needs to tell them up front what the standards are. That is crucial. And so when I've been involved in public hearings, and this is why I tell staff, the first time an application comes in their staff report, the first thing they put down other than the description of the project is, here are the criteria that are gonna govern this, put it right in the staff report. The staff report becomes part of the written record that people that show up at the hearing will see if they wanna review it, and it's right there. So I don't buy the, gee, citizens show up and they don't know what the criteria, they don't know what's going on. That should never be the case, and if it is, then the chair of the hearing, if it's a plat hearing, whatever it is, should start off the hearing by saying, we're here on an application for preliminary plat approval for a 200-lot subdivision in this neighborhood. The applicant is so-and-so, blah, 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 go through the background criteria, here's where the property is located. Next slide. Here are the criteria that govern this application. Put them up. And if you don't have a projector, pass it out. Make a copy of your plat criteria or the criteria in RCW 5817-110 that govern plats, and make sure everybody's got it in front of them, and they just keep referring back to that. And so when 20 citizens come up and say, this is going to impact the migratory flight patterns of the bald aspergas bird or whatever it is, I'm making stuff up here obviously, but you can go, well, you know, that's fine, Mr. Jones, but that's not one of the criteria we can consider for this, thank you. That's the way to handle that and help educate them. But there should never be a situation when you're having a public hearing on anything like this and the public's going in and they go, we don't know what the criteria, we don't know what's going on. That should never be the case, never. And I'm not faulting anybody at the city, but I'm saying it's a combination thing. The public needs to review the staff report. I keep going back to that because I think the staff report usually lays all of this out. Every staff report I've seen that's worth anything has the criteria plugged right into it. So it's there in writing, or it's online on the website, you know, but if not, then get a slide and put it up and just, I like leaving it up during the hearing. Criteria for approval of site plan or conditional use permit, there's 12 of them, and that way you keep the public focused. And you don't get off on tangents going, this is going to be a 200% reduction in my property values. Well, sorry, it's not up here. We can't consider that. I'm sorry. If we do, we're acting arbitrarily, which you are, acting arbitrarily and capriciously, we're at risk of having the decision invalidated.
So, Mayor and Bob, I think we have an opportunity for probably some improvement, especially as we come up on some of the hearings that are coming ahead to lay this out. It'll save some of us, especially in meetings I've been in, we've never always set guidelines on.
You haven't seen the quasi-judicial one yet, as you might remember, even for the legislative decision that was in front of you, the annexation, there's been a fair amount of discussion from staff to the public about these are the legal standards and here they are in the statute, and yet you heard from citizens, well, we don't think that's the standard, we think the standard should be something else. we can educate and we will educate, and we can't make people accept
What I'm
the answer
suggesting
is.
is we have an opportunity with some fairly, controversial, high-profile stuff coming up,
Yeah.
to have this screen down with a slide saying, this is what we're here to discuss, these are the things that will be considered, and that will save you, as the arbiter of the meeting,
Right.
theoretically, not, your arbiter, not theoretically, but theoretically it will save you from having to, enforce the rules every 33 minutes.
Well, and that's precisely what we're doing this tonight.
Right.
So that's a good point, and that's a good process, and again, none of my comments are made to be a slight on the city. I'm just, these things happen, this is good communication, educating the public, and keeping focused on the criteria. I cannot emphasize that enough. You've seen that in almost every slide. I feel like I'm beating a dead horse, but it's really important, because that's where cities get off track. I'm gonna zip through real fast. I apologize, I didn't realize how late it was. I'm gonna really zip through a bunch of these. If somebody has questions, let me know. I'm gonna talk fast about the record. The record is what supports your decision. We've talked about a whole bunch of these things. The record should include at a minimum the application, staff report, SEPA determination, all these kinds of things. You need to adopt findings and conclusions by the deadline, either in state law or code, and you should know that if you're a decision maker. And I don't know how many times I've seen cities get sued because they didn't make a decision within the quote 10 days or whatever the code requires, and they go, I didn't know we had a requirement in our code to make our decision and make findings within 10 days. Well, you're deemed like a judge to know the standards in your code. If you don't know that, you're running a risk of getting sued. So
Public letter. I'll get a letter that says, you're gonna do this, and you're gonna drive field mouse into my property, that's a public health issue. According to your prior comment, I should disallow that public letter?
Here's what I would do. If it doesn't meet one of the code criteria, I would put it into the record, but make it clear it was not considered and did not form a basis for the decision.
Part of the finding and conclusions, there goes.
Yeah,
And we've done this every time in this process.
Perfect, okay. And one way to do it, by the way, is have staff or others, or your city attorney, help craft the findings on big controversial projects. I'm not talking about, a setback variance or something like that. I'm talking about the big projects that everybody's showing up to see. You can put in findings and say, 44 people submitted letters complaining about the impact of this project on their property values. Unfortunately, the council cannot and does not consider those as part of its decision. They are outside the scope of the criteria that govern this application. So the Snoqualmie code, blah, 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 blah. I would do something like that in the findings to say, look, they submitted this, we're aware of it, but we're not considering it, and it did not form a part of or a basis for the decision. Okay? Yeah.
Just a quick sideline on, because some of the examples that you've been talking about have to do with potential environmental impacts, and we won't go way into detail on this here, but the State Environmental Policy Act provides a vehicle for consideration of environmental impacts, generally speaking, in addition to